Hey guys, welcome to the stream for the Darrell Brooks show. On the right side of my screen here is branch 10, which I think is Judge Havas. It's not streaming yet, which is not necessarily an issue because it's scheduled to start in about 12 minutes from now, so they may just not have it on yet. But I don't control if she streams it, and I don't control if she even does it or when she does it. So if it comes on, I'm going to pop that up right away, but if somebody else sees something, just let me know. And let's hit some things here that I plan to talk about, and plus some news on this case that you guys are already hitting in the chat. So what are the charges? These are related to Erika Brooks. There's 2 charges of intimidation of a witness. There's 2 counts of bail jumping, a second-degree reckless endangerment, a battery, a disorderly conduct, and a resisting and obstructing an officer. So those are all the charges that he's facing at this point. And this is the final pretrial conference. Now, if you remember, this trial was scheduled to occur before he was going to deal with the shooting charges that just got dealt with, but this was moved out. And I think that matters for what we're about to talk about, which is the news of his motion to, or his attorney's motion to withdraw. So I just saw this. I didn't see it before I did the weekly docket this morning, that there's a motion to withdraw filed by his attorney. Now that isn't, I've seen some questions about this in the comments. That's not a procedural motion to dismiss the case or something like that. That's actually the attorney trying to get out of the case. And once you appear in court on behalf of somebody, you have to have the court's permission to leave out. So that's what the attorney has filed here. Now, why? We'll speculate in a moment, but now I'll give you my conspiracy theory. And that is that perhaps they had this plea bargain going on potentially in the shooting case, and the attorneys knew this guy was going to go nuts on the Erika case, so they asked the court to push the Erika case out so that they could at least conclude the shooting case and then withdraw out of this case. And that might be one reason why the guy was so frustrated the first time we saw him talking about the plea bargain. I'm talking about Brooks' attorney, and then they finally did conclude that. Having concluded it, now here's a motion to withdraw, and that's either a big deal, big disagreement, I think, between Brooks and his attorney, or what everybody is thinking, he's going to want to go pro per, pro se, propane, profane, or whatever it is he wants to call it this time. Now, it also can be things like, the attorney has an issue going on in his personal life and he needs to get out of this case for scheduling and stuff like that. So I don't know for sure. I haven't seen the motion, and he probably wouldn't put that in there anyway. But I guess we're going to find out a little bit about it maybe in this hearing. Because what you would normally say, especially since you're at the final pretrial conference, is it's a big deal why I have to leave, Judge, and here's a big reason why I have to do it. And here's the other lawyer that can immediately take over, and they can do it on time, or they need another month or whatever. That's probably not it. So I would gamble with most of you guys saying that this is a shenanigan by this idiot. So that's what I think is going on. I'm keeping an eyeball and making sure this is trying to refresh itself. We're still 9 minutes early. And let's see, we got a comment here. It would be too much of a coincidence. Yeah, I say, you put the facts together and think, well, what's the likely situation here? And the likely situation is he's going to do something dumb because that's what he normally does. And I think that might be what he wants to do here. And it's, may or may not end up having the effect that he wants to have, because Erika, from what I understand, is prepared to testify and do it again. She's done it once and outsmarted, outwitted, outclassed this clown at the last trial. And I think that would be the result in this one as well. But I think from the history of the comments that he's made, plus some his mother's made, they kind of blame her for this predicament, which is, of course, absolutely ridiculous, but in keeping with the theory that nothing is his fault. I think these are the same attorneys that were representing him on the charge that he just settled. So it's my opinion, just speculating, but guess that this trial was continued so that they could get to a conclusion on the other one, which was the right thing for them to do and get it done. Perhaps knowing that he was going to go bonkers here and want to fire them. And if he fired them earlier, that might lead to problems in concluding the other case, which the other case concluded with felon in possession with a 2-year active sentence that runs concurrent with the sentence he's already on, with almost a year credited. So that was just an academic exercise anyway. It didn't really matter, but it allowed them to conclude that. and then get to this point where they're filing their motion to withdraw, which is likely due to his desire to go pro se, etc. Give you a little bit of news here coming in, which is that the judge says that Shabusiness is found competent to proceed to trial. So I was watching that before I started this, but I guess it has concluded and the judge reached his decision. And in that case, they're supposed to start jury selection this afternoon and the trial perhaps next week. Yeah, so let's talk about some issues here in this while we wait for the court to start up a comment. His attorney doesn't understand the flag has an eagle on the pole, or that this is admiralty law. And that's right. See, that's what Brooks has, is what a lot of people on the internet has, which is opinions that are unburdened with facts, training, experience, logic, or anything like that. So when you don't need those things to form your opinion can't be dissuaded necessarily by those things. So his attorney, unfortunately, is probably constrained by an understanding of the law, where Brooks' mind is free to construct the universe he wants. And in that universe, if your flag is wrong, you can murder people and beat women and stuff, and you shouldn't be in trouble. In fact, you are the true victim. So that's his situation, and I imagine his attorney is not going to engage in any kind of nonsense like that, so he wants to do it. Now, the other issue I think people have raised before, which is a good point, which is he wants to do the cross-examination of Erika. Maybe so. I would agree with that. And there's been some speculation on, well, look how he behaves to a female judge versus a male judge because of how he behaved during the shooting charge hearings and the plea bargain session. Yeah, I get that. But what has happened, at least on the docket, and of course, these things are always subject to change, is that this has moved off of Judge Havas's calendar for trial and onto a male judge's calendar. So she's going to handle this pretrial conference. Then it goes over to this other judge. And I don't know whether that's going to get continued or not. If he says he wants to represent himself, the judge may say, well, are you ready to go? And he says, yeah. Then they have to do some competency evaluation for that. And I'm not talking about whether he's necessarily too crazy to go to trial, but Wisconsin does have a certain criteria for the judge to grant self-representation. It cannot be a high bar because of the Supreme Court precedent that this is a constitutional right and you can't unduly burden it. But it doesn't mean that it's nothing. So the judge would likely have a discussion similar to the one that Judge Darrell had with him about the risk of going pro se and all those things. Because the law doesn't require you to know the law or procedure of the law in order to represent yourself, but it does require that you make a competent decision to do that. So if you're aware of the risk and you decide, I want to do it anyway, then okay, you can do that. You may not be good at it. That is the story of a lot of things that I've done in my life that the law has not prevented me from trying, irrespective of my competence. Yeah, and let's read this comment. I like that one. I do find it funny that every time Erika's name was mentioned at any point in the Waukesha trial, he blew a gasket, out of control rage. Yeah, he did. He's that kind of guy, right? So, and the same person, I think, said if he represents himself again, this trial will go about as well as the last, I think. It'll be a little more streamlined, of course, but in terms of his insanity in the way he behaves, I have no reason to disagree with you. He's already got all this stuff figured out, and I already have bingo cards ready from the last trial of ridiculous things that he would utter, and I thought that would be an interesting game to play while watching him, but it usually is solved in a few seconds because he throws everything out pretty quickly as he gets going during the day. This person says, Wisconsin has had several cases overturned by not allowing a defendant to represent themselves. Yeah, and that can be the case. So because it's a constitutional right, you cannot unduly burden it, and you can't put them through a law school test or ask them if they understand 8 exceptions to the hearsay rule or things like that. You have to talk to them about what you lose if you don't have a lawyer. And remember, whether he did say to Judge Darrell that, well, I want standby counsel. What's up? And then she said, well, I'm not going to give it to you. And Wisconsin law says that is up to the trial judge, and that the appointment of standby counsel is for the benefit of the trial court and not for the defendant. So it doesn't create a right for the defendant to have it. You either get the lawyer to represent you or you do it yourself. You do not have the ability to demand of the court system that they provide you with a paid lawyer. Okay, so now you want to hire somebody, you go on and build your team, but he doesn't pay for things himself. He wants other people to do it. And so he would have to have a free lawyer, and the state does not have that burden. So generally speaking, sometimes people are like, well, this is, I don't like it. He shouldn't be able to do it. The attorney should leave and take everything. And it doesn't work that way. You've done this work on behalf of this client. You're being paid by the state to do it. They'll turn over what they have for him. Not that I think it makes any difference. Does anybody think you really made anything out of the last one other than a giant mess? So, yeah, I don't think that matters too much, but, all right, we're getting closer to the witching moment of 11 o'clock my time, 10 o'clock their time. So I'm keeping a weather eye on this stream for branch 10 and see if they light it up here soon. It's always touch and go on catching these courts doing the streams. I did see that they did a good job streaming the Shabusiness stuff, and I think they even caught Sarah Boone, who this case was put off till October, but the judge and defense counsel said, we all agree that date's going to slide further. So that case will not happen anytime soon. And they are trying to have a hearing in September for funding for an expert for battered spouse syndrome. And then she asked the judge, why didn't you post my letter up onto the clerk's site? So she wants you to read this letter that she has. So if it posts and I catch it and I have the time to do it, I'm going to stream that out because she wants us to read that letter. It's got something in it. All right, so here's a question. Since he has a lawyer doing his appeal from the parade trial and did his last trial, will the judge even consider letting him represent himself? And my answer to that is yes, because while you may not have liked his antics, and I didn't either, he made it all the way through the last trial, through the verdict, representing himself. So under what basis would that lead you to say he can't do it again? So the judge can't say, well, he did it once, I'm not going to let him do it again. I think he has to go through the questions that you normally would ask somebody and make the decision. And there are times when they can deny the right to represent yourself, but hasn't Boone been in jail for 3 years now? She will tell you exactly how long she's been in jail once that letter posts, because she's a very Rain person-esque in documenting how many hours and minutes and days and holidays and things that it is. So we'll see. But yeah, I think something like that. Another letter, sheesh. That is disrespecting the fact that Sarah wants to correspond directly with you and every other sentient being on the planet, what she has to say about her situation, which is novel and new every time that she writes a letter. And it's very interesting. And if you don't believe me, ask her yourself. Let's see. Yeah. There's a lot of comments about what Brooks did in his last trial. It was ridiculous as a pro se. And, a lot of novel things. I never appeared in court and thought to construct a box fort out of bankers' boxes of evidence. I never did that. I never, thought outside the box that way. So a lot of techniques there that he's engaging in. But I did have, cases against pro se people. So I formed an opinion of that over time. Let's see. Still checking here. I'm going to hit the refresh button, but it also refreshes itself. If anybody sees anything, let me know. But this, in theory, this branch 10 will light up when she starts the stream. One time I was representing a police department against a woman who was pro se in federal court, and she had mental issues. And she called me from the library and accused me of following her and putting her books back as she was trying to get them together to research. And then in theory, although she called me in my office and I answered the phone, that I was stalking her and disrupting her research materials, which I will tell you I was not doing. And then she didn't believe me. And she said that all the discovery we were doing was just a fishing expedition. And she's surprised I didn't ask her her shoe size. And I said, well, I already know that. And then that lit her off pretty hard. Oh, I bet you do. And I said, look, let's just agree to disagree. But she was never mean to me and I was never mean to her, but she had mental issues. And then she was not trying to be violent to other people like this idiot. So is my stream broken or has it not started? I don't know about your stream or my stream. I can only say that as I'm refreshing here, I don't see a stream started in branch 10, which is Judge Havas's courtroom. So if somebody else sees that appear somewhere else, let me know and I'll try and get to it. I've got their directory popped up too. Hypothetically, I guess she could show up in a different room or something like that. So if anything can go wrong in terms of court stuff, you need to plan on it going wrong. Will Erika willingly participate in this case? And the answer is yes. And you can go, and I put it on again, posted a link to her own YouTube channel, because I'm not ripping off her videos. After my live stream that I just did this morning, the weekly docket, I put a link to her channel and a comment to somebody reply to a comment. She has a channel and she has spoken on this, and she appears rock solid. She is not afraid of this loser. So, all right, here's somebody saying, it hasn't started yet. I checked, and I appreciate that, because it confirms what I'm experiencing as well. And sometimes it could be a few minutes late, and sometimes they may not do it. So we'll give them a little time here. Here's someone who says, I think she has a case before Darrell Brooks. And right, yeah. So oftentimes, especially on these pre-trial conferences, they got a lot of things scheduled for that day, not just one idiot. And they don't. It's not like doctor appointments necessarily, where you have a 10 or 15 minute slot. They'll calendar several people in and take it as it goes. Sometimes, if an attorney's there and he's got one person ready, if the other person was going to be 10 people later, the judge might let him go ahead and do both so that attorney can leave. I don't know why that affects when they would start the stream, but many things can happen in court. They could have something that they want to talk about that they don't want to broadcast yet. I don't know why it's not streaming, but many things can be happening. It was great when Erika kept calling him Mr. Brooks during questioning. Yeah, I thought she did just fantastic in that trial. So she, as I said earlier, she outclassed him in every way that you could measure that, I think. Here's another question. Is there a motion to withdraw? Yes. Went over that at the beginning of the stream, which is Brooks' attorney has filed a motion to withdraw. And if he leaves, then either some other attorney has to take his place, or the speculation that I have, which I think some people agree with me, is that this is Brooks' chance to say he wants to go pro se again, which I think is bolstered in further speculation by the fact that this case should have been dealt with earlier, and the defense asked to move this out. Then they got the plea bargain done. His attorneys got the plea bargain done on the shooting charges, and now they file a motion to withdraw. So, are these cases keeping him out of federal prison? Yeah, I don't think he's got federal charges, or at least not that I know of. So, and here's from the Philippines, and good evening to you there. Hey, cool. I've never been there, but I just know it's cool. Let's see. Now he's got, a couple bail jumping charges here. So, he's charged for bail jumping for this case. So that's really what it comes down to. Maybe actually has two, because he bail jumped a couple of things. Stupid. I'm guessing he wants to represent himself so he can ask her questions an attorney would not. Yeah, or either he just wants to do it himself, because he wants to be the kind of person that he is. The judge has some control over that, and if you push it too far, then the cross-examination can be deemed ended if all you're doing is harassing. And Judge Darrell did do that. So here's a question I think came up in a comment yesterday, and I didn't get to it. Is there a legal reason which might have prohibited the day bail kids from attending Lori's trial? There's not one that I necessarily know of. I don't know their posture on this. Aren't they thinking that their dad's innocent and stuff like that? So that may be the motivation for what they were doing. But I haven't read all the court documents and stuff to know anything about that. There are people chiming in. Oh, that's interesting. That's probably spam since it's local. Hello from Raleigh, NC, so that's highly local. I'm in the Yates Mill Pond area and Burlington. I always think of the old coat factory, hypothetically. Drove through Burlington. I can't count how many times I've been through there. All right, so we're all, of course, waiting here to see if this happens. And I'm watching Branch 10 and also watching comments to see if anybody finds out that they know something I don't know. So a new member, thanks and welcome aboard. And there's some extensive content there, detailed content. The members vote on that. And then the live stream coming up will be on double jeopardy. And I saw a comment about that a moment ago. He's bail jumping, prosecuted, double jeopardy. So I don't know if that's serious or not because I don't know the details of what you're talking about, but the members will know because we're gonna hit double jeopardy pretty hard later this week and talk about that. So welcome aboard there. And if you want some stickers, see the comments on that and I will send them to you. I have a Burlington Coat Factory 1 mile away. Didn't they change that now though? It's just like Burlington with a heart on it. At least that's the one that's up here. So I think next to the REI. So yeah, Lori Vallow's sentence is going to be on July 31st. And I believe the court said they're going to stream that. And so that's why they're denying media requests to show anything from that. Well, look at that. Hello from Greece. That's awesome. Very cool. And Italy. I guess we're that weird over here that our cases are so much weirder than yours. You check into these. I guess I'm not surprised by that. Still nothing. And so you can only apologize for that to a certain degree because, as I say, it's the judge's decision to stream it or not, when it streams, how it streams, and what happens when in her courtroom. So none of us have any control over that. And if they never show up at the end of this, I'll certainly change the description to reflect that and then prepare for comments angry at me that the stream is not actually showing. You know, it's possible that this motion to withdraw fouled this up because it was supposed to be a final pretrial conference. So it could be that something has happened due to that. It says we don't get to watch trials in England. So it's very jurisdiction dependent in the United States. They don't show federal trials, for example, and every state is different on whether they show trials and under what conditions they show trials. I mean, you notice I'm not showing North Carolina cases, and that's not because we don't kill people here, because they certainly do, and they can be streamed or not, but it just depends, and all the states are different. So you see a lot of, like, why is Wisconsin so terrible? Why is Florida so terrible? And to some degree, you have to give them credit because they're showing all these cases. They're terrible people make their way around all of the United States. So here's another new member. And thanks and welcome aboard. I think I mentioned earlier, if you want some stickers, you just look for the commentary on that in the member section. I send them out to you, and that's free. And also you vote on the streams we do, which will be double jeopardy. Not this week, next week. I think I said this week, but the voting stopped this week. And then I have to actually do the work for it. But double jeopardy will be a good topic. And then there's some other streams on there to go into some detailed legal topics that people say. Florida is not terrible. I certainly agree with that, but you might think it's a crime haven based on the cases it show. But as I say, that's because they show cases, and it's kind of the same thing with Wisconsin. So states that broadcast their cases look like maybe they're more violent than some of the other cases, but that's just because they're, to some degree, they're showing those things. So in Scotland, oops, I hit the wrong one. In Scotland, we get to watch trials on TV, but all the parties have to agree. Yeah, now here, of course, the party can object and stuff, and sometimes there are good reasons to object. You don't want the stream to affect the trial, certainly, and that could happen. But on the other hand, you know, the public sometimes wants to see these cases, and I think on net, because, well, I think on net it's good to show these trials. I did watch a murder trial streamed a long time ago in North Carolina, and you wouldn't have known all the things that were going on if you hadn't seen that. And that was the case in the Depp case as well, I think. And people start to learn maybe a little bit more about how the legal process works. That's why I switched this channel to talking about legal things from what I used to talk about on it. There can be a bridge between, well, why are they doing that, to explain why they are doing that, because not everything in the law is intuitive, or you even have to go to school for years and have this license and continuing boring education that you have to do. So all courts should be transparent, in your opinion. And, you know, yeah, I pretty much agree with that. Pretty much agree with that. Now, you know, should every trial be streamed? I think having it in the discretion of the judge based on certain things makes some sense. But I think it's a net good to show it. But not always true, because there are weirdos out there and they start to threaten witnesses and or witnesses watching. They're not in the courtroom and they're not supposed to be, but yet they watch it on the live stream. So that can be an issue too. Look at that. Hello from Casper, Wyoming. The great state of Wyoming. Love the West, man. It's just so beautiful out there. And it's like some parts of Idaho and some other places, like I would not want to be a car brake salesman because the road just goes straight for like 200 miles. Like you never turn or wear anything out. But in the mountains, I suppose that's totally the opposite. So here's a situation where a person says, I can't believe that jury didn't give this guy the death penalty. I think was the Border Patrol guy or whatever. Yeah, that was awful. But the application of the penalty is fairly arbitrary. And depending on the state, the procedures can be different. But you're doing something different. Normally you ask 12 people to come in and determine whether a set of facts occurred, regardless of punishment. Did this person do this, this, and this? And if they did, they committed the crime. And if they didn't commit the crime, or it's not guilty at least. So if you don't prove it, state, then we're saying no. And if you did, we say yes. Then you transition to the level of punishment, and that level being killing somebody. You're asking 12 people off the street to reach an agreement on that. You're not going to get the result that you wish you did all the time. That's why you have a jury, is to let people put their thoughts for there. And I come from the perspective, at least of the principle, that there are people who have done things bad enough that I think it is just fine to take them out of the pool, send them on to their eternal reward. That's my theory. But the application of the death penalty in terms of potentially getting innocent people, putting victims' families through the ringer, and then having them be disappointed when the penalty is not granted, but they see it granted in some other case. There are a lot of issues with the application of the penalty that dampen my enthusiasm for it. Here's another new member, man. We don't even have content going on here. People are joining, so I really appreciate that. We're just waiting on the stream. Tell you, like tell the rest, free stickers. You just look for the stuff about that if you want that, and then vote on the content that you want to see, that you want to learn about, and then also some in-depth stuff. So on the main channel, of course, I go over everything that's going on and still touch on topics we touch on in the member section. But in the member section, people can say, I didn't quite get this or get that. Can we go into that into more depth? And that's what we do. Here's somebody who says, I'm nearly 70. No idea how our court system functions. You don't look a day over 39. Having never been in one except a couple of tickets. So that's good. Staying out of the courtroom if you don't work there is a good idea. If it's not streamed, we'll get transcripts. So at least for this hearing, I don't think there'll be a transcript, but there'll be some kind of order. Here's what I'm guessing. And, I don't like guessing too much, but let's do it because we don't have anything to look at but this screen. And that is that the motion to withdraw has fouled up the final pretrial conference situation. That's what I'm thinking. So I don't know what to say about that. Of course, you may have been talking about streaming something else than this, but I answer for this. This is all I got. 46, spring chicken. Am I in the boat of thinking a thing like that? No, for sure. Let's checking out comments for stuff here. Well, all right, I'm going to slip over to here real quick and just, I checked to make sure somebody was streaming in Wisconsin, and there were. The small claims courts were streaming. So it wasn't like their system's down or something like that. We're going to check the intake court, nothing. Preliminary hearing court. So I don't really see a whole lot going on there. I think we'll give it a few more minutes and then check out. But if it's any questions on this, we'll go over his appeal here again in a second. Another new member, you probably hit that button in time to hear the rest of the stuff about stickers, content, and all that stuff. I don't want to badger people about that too much because it's not meant to exclude anybody. It's just extra stuff. So I can't remember if I mentioned this at the beginning of this or not, because I knew we had this motion to withdraw coming up. I think I just went over the charges, and that the transcript for his primary case has been extended to November of this year for the court reporter to provide that. And you need that before you actually file your real notice of appeal. He's filed a notice of intent to seek post-conviction relief, or whatever they call it up there, requested the transcript. When you get it, then you have a certain amount of time after that to actually file your notice of appeal if you're going to do it. So can you get extra credit for serving on jury duty if if you're in law school, they never gave me extra credit for anything. And I recently had to go to jury duty myself, but it worked out. I didn't get called, and I didn't want to because it was the first week when Wake County went on the experiment in North Carolina where everything is going electronic. So now for Wake County and 3 other counties in North Carolina, you can search for cases like you could in other states. And also they are providing case documents, so you can find those and not pay for that, I think. It's free for everybody. It's free when I do it. And I don't think that's because of the attorney login I have for filing things. But I could imagine the first few cases are going to court and you're trying to do all your exhibits, all your motions, all your court orders on tablets or little computers and things like that. And they warned everybody, be prepared to have your batteries charged because we don't only have so many plugins and stuff. I'm like, oh man, I would not want to sit through that as a juror. But I was in the second group, and after a while they said, you guys can just leave. So good question. Do these transcripts include the sentencing portion of the trial? I can't remember off the top of my head what all he requested, but I would assume he requested that too because they may want to argue about sentencing for whatever reason. British Columbia, Canada. Very cool. All right, so let's see. Will there be a no hat reveal at 100,000 subs? I don't know that I'll be on Earth and that happened on this channel, so I don't know about that. However, I have posted a video without a hat on before. It's just part of my thing right now. But when I did the October special, the Haunted Southern Law Mansion, I didn't wear a hat. And we journeyed outside of this room here to outside of the house, and I did some things there. So if you want to see the best special effects I could come up with, you just go back to October and check that out. And wore a blazer and no hat. So it's quite fancy. All right, so we have a new member here. Thanks a lot. And you probably heard before. Free stickers if you check out that the stuff on my on the member section. You get to vote on content. Right now we're looking at Double Jeopardy for the next live stream where we will do videos where we go into detail on subjects that people have picked out and said, hey, I want to know more about that. And we put it up to a vote, and I don't veto it. Whatever you vote on, we get into. And you guys come up with some really great questions on the mainstream and in the member stream. That's for sure. It's quite challenging because, you know, nobody knows all the law, and certainly I don't. So what I do is try and figure it out before I tell you what I think. So I'm not giving you bad disinformation. Welcome from New Zealand. I would have to say from where I sit in the United States, every image from New Zealand is beautiful and spectacular. So hopefully that's true for you where you live there. Let me get back onto this thing and make sure it is going here. So I'm sorry about it because I know you guys are tuned in to see this hearing, which would be the final pretrial conference for Erika Patterson's case. Now remember, if they were doing it, she doesn't have to be here for this. This is an administrative thing where in theory the attorneys would say, okay, we're ready to go, judge, or we got this one small thing to deal with, or we want another extension or whatever. But in theory, it's your chance to coordinate finally before going to trial. But instead, yesterday, his attorney, Brooks' attorney, filed a motion to withdraw. And I would guess that has fouled this up. So, you know, I'll keep an eye on it. And I'm sure you'll see from other sources when we get a result from this. They'll post it on the docket there. And I may have that up, actually. Let me see if I can get over to it. View case details. I mean, all I'm seeing right now is the same thing we talked about, the 720 notice of motion, notice of motion and motion to withdraw filed is what it says. And I think that's probably is the grounds for this delay. So here's a person saying it seems redundant to have more trials for Brooks, seeing as a 1,000-year sentence. And the judge in the shooting case, when they were doing a plea bargain, said this is an academic exercise. I said I just happened to use the same word earlier in the stream that he did because it is. But it seems to me that Erika wants to tell her story in court, and I think it's fair to let her do that. She was a victim of his for sure. She was hit first. And if the court system had dealt with that, and not let him out and had moved forward with the situation, he probably would not have been out on the street to do what he did during the Christmas parade. So he's awful. And the system really let everybody down. Wait, there's a motion to withdraw? That is correct. Brooks' attorney has filed a motion to withdraw, leading to speculation that he wants to go pro se, which leads to my further speculation that that's why they asked for this case to be put out past the shooting case, so his attorneys could finish wrapping that up, knowing that he was going to pull this stunt before this case actually got to trial. That makes sense to me, but I don't know if it's true. Covey thinks he will let Brooks free. Yeah, maybe. Maybe he thinks that, but he has filed a no merit report in the Halderson case, and it remains to be seen what he will file in this case. This case is complicated, and I imagine if you wanted to come up with grounds for him to make some kind of argument, you could, but whatever. He's where he needs to be. Here's somebody saying, please let him go pro se. So, I'm putting my odds on that's what he wants to do. And somebody says, Judge Havas will enjoy this. She will bury him. However, I mentioned earlier that the trial now, although it could be put off, was moved off of her calendar and put onto a male judge's calendar. So she was going to handle this final pretrial conference, and the trial will be handled by a different judge who happens to be a guy. Can a judge refuse to let a lawyer withdraw? Yes. I tried to withdraw out of a case one time due to significant disagreement with a client, and the judge had a hearing with us and then said, okay, ABC, but if ABC doesn't occur, you can make this motion again. I'll let you out. And then I was able to make the motion again and get out. And the judge told the people, this isn't Burger King and you will not be having it your way. And I was happy. That's very rare though. I think I've only done that once. But once you appear in court, like you can fire your client can fire you, of course, but you can fire your client. But once you appear in court, you can only do that if the court lets you out, okay? Because you're an officer of the court. So that's an issue. And one reason why I don't just pop into court on anybody's behalf for whatever they happen to come through the door on. I never did that. Certainly don't do it now. All right, so that's enough talking about firing your lawyer or your lawyer firing himself. In fact, I think in the Meghan Markle case, now that I think about it, they tried to get the judge thrown out, and then the lawyer tried to withdraw and couldn't right away, I think, actually, because she would not provide her information to the court. She wanted to keep it private, and they said, well, then we're not going to let you leave until that's resolved. So I think the rule up there is a question about where they have to turn the file over. I think they have the ethical duty to do that. And I'm not staring at it now, but I did look at it a while back, and my recollection is that they would need to do that. And think about it. I mean, that's your lawyer up to that stage, and to withhold all the work would create an impediment to your client. You've done that work on their behalf, and also you've been paid to do that. You're not that I think that necessarily makes a difference under the ethics, but in theory, you're paid by the state to do this work on behalf of this defendant. If the defendant got a new lawyer for whatever reason, you would have to turn that file over. And now the new lawyer happens to be himself. You need to turn that file over. Is there a difference between pro se and pro per? To be totally sarcastic, just the letters as far as I'm concerned. And as Judge Darrell told Brooks many times, I don't care what you call it. And there are a lot of technical terms in the law, and sometimes they are operative. Sometimes they do amount to something super important. Like if you dismiss your case with prejudice versus without prejudice, well, those three letters and that, they make all the difference in the world. A lot of difference between lightning and lightning bug. But sometimes people think there's more formality in the law than actually exists. Like some people thought, well, Brooks is going to get his whole case thrown out because Judge Darrell let him mark up a form. The sacred form was violated. And I searched that actually, because that's kind of idiot I am, and showed some of the law on that in a video to counteract that belief. His use of the organized files in his past case was frustrating. Yes, except for the box for it, because that was a novel legal thing there. He won't get away with the same crap here that he did in Judge Darrell's courtroom. I think that's likely true, and for many reasons. And one is, now that he's got this giant sentence, the whole system doesn't have as much of a stake to cater to him as much. Plus, this case is more streamlined because you really got the one victim here, right? So here's somebody saying that Havas said she was moving to more severe crimes, murder, drugs, etc. Judges rotate. So, right. So this case for trial, again, has been moved off of her calendar to a male judge's calendar. So this would have been her, and is, if she's doing it, her last thing, I think, for this case. Let's see. Here's somebody dunking on me by saying that they are fluent in Latin, and I am not, although I had to learn various Latin phrases in the law, like res ipsa loquitur and things like that. And I think if you make the law more obscure, then you help protect your ability to be the people doing it. I mean, why not just put that in? Why not just put that in English? But whatever. And this says it's in Milwaukee. It won't be as nice there. I hear that, except for they're the people who let him out, of course, in the first place, when they should have kept him in jail. That was during some issues with delay in the system responding to the COVID situation, and then also just the way that they do bail for the types of things that they do. So, and do I think she lost the nomination for the Supreme Court because she was too lenient? I don't think that. And didn't she just lose the primary? Like, she wasn't able to run as a Republican, and she never made it to the general election. So probably they already had somebody. The party wanted to be that person. That's what I think. I do understand and respect the position that she was too lenient on him and things like that. But I guess my view would be it's hard to run a trial. And if she erred on the side of being too hard on him a couple of times, he could have his convictions thrown out. So as aggravating as it was, she wanted to be safe on this. And I think that's, so I give her the benefit of that. And I think she came back pretty good during her, during the sentencing when she made her comments. Yeah, he was out on bail despite violating original bail. And that's all true. And a disaster. And he was not, as I said before, he's maybe the worst example you're going to pick out there like this, but not the only one. There were other people let loose too easily and who went on to commit violence, killing people, hurting people and stuff like that. So it's awful. Yes, he's got his charges currently on this set of cases is 2 counts of intimidation, 2 counts of bail jumping, a second-degree reckless endangerment, a battery, a disorderly, and a resisting and obstructing an officer. Those are the current charges. Whether they drop some of those to consolidate or whatever, who knows, before trial. Somebody said she was too conservative, and the Judge Darrell, and maybe so, but I think she lost at the primary level, right? I'm not totally sure on that. And if she did, then I guess maybe they didn't want her to, maybe the Republicans don't want a conservative person. I don't know. I can't say. I didn't think she went to the general election, though, I guess is what I'm trying to say. That could be misinformation. Now, I'm going to post this, but I'm not going to try to say it because it's more Latin dunking, okay? I'm getting dunked on from globally at this point, which is fine. I fully accept that. Yeah, if I'm not going to put in the effort to learn this stuff, then I get dunked on. And then somebody points out, which I've heard this before, I don't know it personally, that Judge Darrell released someone that killed their wife soon thereafter. Yeah, that's what I'm saying, that there were many instances of this happening. And Brooks was an example of that, maybe the worst example, but not alone in doing that. Okay, so somebody says she did lose the primary, but the guy who beat her was a far-right nut job, and he lost the landslide. So in theory, I guess the Republicans wanted somebody more conservative than her, and then the state didn't. So, but I think the main point I'm trying to make is she didn't make it past the primary, right? So here's a good one. I think you mentioned the past attorneys or officers of the court. Covey shouldn't stake his career reputation on a bogus appeal. Right, you are. And you're not supposed to make frivolous filings. So the way they handle that is when you're appointed as an attorney on appeal in Wisconsin, you can file a no merit report, which says I've assessed the case. I've looked at these things, considered this law. And I don't see something that I can raise as an issue of merit to support this appeal. So I file this no merit report. Now the client has certain things they can do with that. They can accept it. They can disagree with it. The Court of Appeals will assess it. They'll review your report to make sure they don't think you missed something. the client can disagree with it. So, you know, if the Court of Appeals thinks, no, you missed it, they can tell you to go back and look at it, or in theory, they could give another lawyer. But assuming they agree with the no merit report, then the person is done with their free lawyer. But you get more leeway when you're the criminal defense attorney to do some things. But, you know, in theory, you're not supposed to file frivolous things in court. That could be, the hammer can be dropped on you. And I will say that haven't been in too many, but of monetary sanctions for misconduct in a case that I've seen have been levied against the attorneys and not the parties. They want you to pay up. And the famous one was a pretrial, or was a conference going on with a federal judge. It was famous, at least where I was at, because you didn't want it to happen to you, having kind of an informal conference with the parties on discovery. And it occurred that the judge was dissatisfied with one side apparently not providing the discovery as the court had directed. And this judge, who was a nice person, stood up, put his robe on, and said, let's get back in the courtroom, go on the record. And they did. And the judge told the attorneys to come back with their past tax returns, and then levied a significant fine against them and ordered the firm not to reimburse them for that. And I mean significant. So we all knew for that judge that you can make honest mistakes. You could be zealous, but you need to be careful about overstepping that situation. And that was always how I felt in federal court, that if you get them to the point of thinking there's sanctions due, then you're going to get sanctioned. Don't do that. All right. Let me look at this case again here. I don't know war story about it. All right. So I'm still just seeing that this notice of motion is filed. In other words, I don't see a disposition recorded in the court yet for any hearing this morning. And we have been at it for quite a while. So I'm going to crank this stream down, and we'll just have to see later what the court does with it. Again, to close it out, I think it's because of the motion to withdraw may have fouled this up. And of course, maybe the judge just didn't want to show it, but I'm thinking the motion to withdraw threw this one off the deep end. So, can the lawyer charge a client for a sanction? I haven't seen that. I mean, typically you need to eat it because you broke the rules, and that's how I've always seen it. And, anyway, all right, so let me switch this over. And I appreciate everybody coming to the stream, and sorry it didn't go off, but we did go over some information together. I certainly learned some things, and hopefully you guys learned some things from each other and the information that I was able to provide. I'll certainly post it on the channel, what I see posted in the docket later of how this resolves. My guess would be there's some, it gets scheduled for another hearing because of this motion to withdraw. It's not what you need to be addressing at a final pretrial conference, right? Because you're about to switch counsel. So we'll see what the judge has to say on that. It might post by the end of the day or something, and I'll take a picture of it and post it up as a comment. And now I got to get out of here so I can get ready for the laid back news stream where it gets substantially crazy. And that's it. And for everybody I'll see on that, I'll see you in a few minutes. And for everybody else, have a good weekend. Although I will say this, if I see that Sarah Boone letter today, I'm not going to be able to resist the live streaming, reading that, because she really wants us to read it. She told the judge, get this letter posted. So I got to check that out. Well, that's it for this. Thanks. Bye.